Good afternoon, ladies and gentlemen of the jury. Thank you so much. I know it's been a pretty long week here, and we thank you for your service to this county, to this community, and to this country. Like I said in my opening statement, that's what makes this country so great, is individuals such as yourself to be able to decide the guilt or innocence of another fellow citizen. In this particular case, now you're asked to, if you remember at the onset of this case, you were asked to look at the one charge of murder and the second underlying offense of felonious assault. Well, guess what? There's another charge now that has been added. I would say probably 2 more charges, 3 more charges have been added. Now it's going down to complicity to murder and complicity to felonious assault, and the underlying lesser included offense of voluntary manslaughter, and complicity to voluntary manslaughter. Now, what does this all mean? The complicity to murder is not a lesser included offense. I want you to be very clear of than just murder. If you find him complicit to murder, you will find him basically guilty of murder. Same thing. If you find complicity to voluntary manslaughter, you'll be finding guilty of complicity to voluntary manslaughter, which would be voluntary manslaughter. So complicity is just another way of coming at the same exact charge. So make no mistake about it, it's not a lesser offense, for instance, for the charge of murder. It's not a lesser offense for the charge of for voluntary manslaughter. That's very important. Please keep that in mind. Now, the elements of the crime. For the first charge of murder, the prosecution has to prove beyond a reasonable doubt. And beyond a reasonable doubt is for every element of the crime, ladies and gentlemen of the jury. That one, that the person, that this defendant caused the death of another, that he caused the death of another. Let's start with that. Causation. All right? They're not even able to establish that indeed this individual, this defendant, caused the death of Mr. Vespers. We had testimony by the expert that says no, he had a brain stroke. That brain stroke could have come on at any time beforehand, hours before, maybe days before. So the subdural hemorrhage, even if you go with the state's theory, the subdural hemorrhage, that could have been caused on by ahead of time. Ladies and gentlemen of the jury, please don't take so much emphasis on the fact that this person got knocked out unconscious. This happens every day. We all watch boxing, UFC fighting. We all watch football. People get knocked out. But guess what? They get back up. So this emphasis on this last punch really shouldn't be, hey, this is the punch that killed him. In fact, he was thrown to the ground and punched a number of times throughout the process. But more importantly, you heard the testimony of the expert. He said the distinguishing hit is when he slammed the solid floor. When he slammed the floor, there was nothing to give back. There was nothing yielding against a solid floor. And you see through the video, he falls to the right side of his head. And indeed, this is where he has a fracture. A current fracture is right here, up in the right side of his head, his face. He doesn't have a fracture in his jaw where this punch supposedly took place. We see the bruises. We see where in his lips and what have you the punch was hit. He doesn't have a fracture there. He doesn't have a fracture when he fell straight back, the supposed knockout punch. But he does have a fracture on the right side where you can see Mr. Kamasai throwing him to the ground. He gets knocked. Now, was that the throw that killed him? In all sincerity, ladies and gentlemen, we don't know. And we can't say with beyond a reasonable doubt that the prosecution knows. We don't know which punch. We don't know which throw. We don't know the fact that he was under the influence of alcohol, what that does to the brain and everything else. We don't know Was it the brain stroke, which we heard testimony? The survival rate on the stroke and the brain stroke is literally about 13%. The survival rate on a hematoma, subdural hematoma, is approximately 75%. It's a much higher survival rate on a subdural hematoma than it is on a brain stroke. You were able to see the pictures that little brown spot when they cut the brain of the deceased, and you can see this brown spot. It's not on the exterior. It's not on the exterior of the brain. It's inside the brain. And you heard the testimony of the expert. That could not happen by blunt force trauma. You heard that testimony. And Brother Counsel talks about, well, you could be anyone to come in and say that. Well, you know, we can say the same thing for Dr. Pena that came in. She works for the county the same as the prosecutor. They get paid about the same people. But even Ms. Pena says there was a stroke. There's a brain stroke, a very serious stroke. And you hear the testimony of the expert say this is a very, very important part of the brain. He akined it to you having computers all around, and some coffee spills on the computer, but the main frame is right here. This is the main frame of the brain. That's how serious it is. But the prosecution wants you to disregard that by their theory that it's subdural hematoma, and by their theory that this is exactly how it happened. So, going back to the charge of murder, they also have to show a proximate result, as we just talked about. Same as the lines of causation, that this indeed caused the death, that the punching of my client caused the death of this deceased. They simply don't have it. We look at the underlying charge of felonious assault, because this murder charge, you have to have an underlying felony, and the felony is the felonious assault. And the felonious assault, you've seen the counsel put up there on the screen, it said that knowingly caused. This word, knowingly. And the judge will give you an instruction. It's right there on starts on page 9. Knowingly is defined. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. Let's stop right there. Does anyone, ordinary person, think that by punching an individual, it's going to kill him? It's going to kill him? Cause great serious bodily harm? I don't think so. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of offense, such knowledge is established if a person subjectively, not objectively, subjectively, which means in the mindset of this defendant, believes that there is a high probability of its existence. A high probability of its existence. Ladies and gentlemen of the jury, the counsel said it open. We all normally think of murder, shooting someone, stabbing someone, beating someone's head with a bat or something of this nature. No one in their right mind thinks by a number of punches. On this occasion, they're claiming this last left punch, which we have testimony, he's a right-hander, he punches the one left jab, has any intention to think there's a high probability of its existence. How in the right mind could anyone think that this punch will have a high probability of causing substantial harm? And especially given the fact that he's already hit this individual a few times, he keeps coming at him. If I hit him before, he's down, he gets back up. If I hit him before and he's down, he keeps coming back up at me. How would I know in my right mind that, hey, this one left punch is going to knock him out and cause some substantial injury, substantial harm? It's just simply not there. We can't set this defendant to a higher standard than we do all of us. It's just simply not fair. And it says also, since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and the evidence. That's straight in the jury instruction that the judge is going to tell you. You will determine from the facts and circumstances whether there existed a time in the mind of the defendant an awareness of probability that the actions will cause a certain result. Ladies and gentlemen of the jury, I don't think anything in that fight, anything, would lead this individual to think that there's a substantial injury or harm to punching an individual, especially when the individual keeps coming at you. Now, I would give that if had he had a weapon, a knife, a gun, a bat, a golf club, something that would give me an indication I'm going to do some serious damage to this individual. They're simply not there. And you see in the videotape over and over again, you didn't see Mr. Wimpey just keep running after individuals to hit them and what have you. You seen him stand in his space, This is a constant theme throughout this trial, throughout the evidence that was submitted. He kept staying in his space. Now, unfortunately for Mr. Vessos, God rest his soul, he kept coming at him. You see that. And he stays there. One time he stayed quite a distance. You see Richter come up. There goes his uncle, come right behind him, over and over again. He didn't chase someone down to hit him or what have you. He didn't do any of that. Or try to hit him while he's down, multiple punches. And ladies and gentlemen, we can't forget, by the way, the kicks. The kicks supposedly on the deceased when he was down on the head, if you remember that. There was the witness, the lieutenant that came in, 29 years experience from the Toledo Fire Department, to testify. Mr. Ray Darrow, said that someone told him he was kicked numerous times, a number of times when he was on the ground. Asked the defendant, was that you that kicked him? No, we don't see anything on the video that the defendant kicked him while he was down. That's another causation issue that the state has to deal with. Now, what's interesting, ladies and gentlemen of the jury, we had, when we began this trial, a charge of murder. And felonious assault is the underlying offense, count 2. And now we're at complicity of murder. And you're going to look at that charge specifically, in detail. And to me, again, the judge is going to tell you what I say is not evidence, but to me, it seems it's counterintuitive. One is saying, you're the one, this defendant killed Mr. Vasquez. The other one is saying, someone else killed Mr. Vasquez, and you aided and abetted, or helped him kill Mr. Vasquez. Now, which is it? Did he kill the individual? Which theory you want to buy? Or now is it that he helped someone else kill? It's changed since the beginning of this trial. I think that's, in my mind, outrageous, ladies and gentlemen of the jury. Now we have another charge that someone else killed him, he helped him.
Judge, I'm going to object this. Please sustain.
Then you have the lesser included offense of voluntary manslaughter. The judge is going to give you the instruction for that, ladies and gentlemen of the jury. The only real difference in voluntary manslaughter and murder B is that there was provocation. Okay, that there was provocation. Murder B doesn't require provocation, and voluntary manslaughter requires provocation. And we all know that this defendant was provoked. He was provoked by Mr. Richter, which I think the prosecutor said, well, he was already an asshole. He was just minding his own business that day, trying to have a drink with his friend. He didn't get to finish his drink. This guy just kept coming at him. He kept coming at him and kept coming at him. And the deceased, Mr. Vasquez, he kept coming at him too. Mr. Wimpey didn't ask Mr. Vasquez to come grab him by any means the first time. He didn't come ask for him to grab him in a bear hug the second time. He kept coming at him. And ladies and gentlemen, what's so important in this, again, I talk about this area of space. When these three individuals walk up to him at the bar, and then in his space, thereafter, he's hitting. He's whoever's in his space, his mindset, at that particular moment, in his mindset, that's what he was going through. We can all sit here, sit back, and judge an individual on a video and say, maybe I would have did this. No, maybe I would have walked backwards. Or maybe I would have walked to the side. Maybe I would have done something. But this defendant, in his mindset, what was going on with him? Was somebody coming with a weapon, a pool stick, another 2 times, and then another with bottles, coming at him, times swinging at him. And God knows what else he's thinking some other people have with their pockets or what have you. This was what he thought at that particular moment, that he acted in the most reasonable fashion that he could. He diffused the threat around him. He punched the individuals that are around him. And ladies and gentlemen of the jury, it's just not what this individual did reasonably, but what the other individual did reasonably. Look who else got into the fight, and look who else punched the same individuals. Cal Mossad also punched Arthur Richter. Cal Mossad also punched Mr. Vasquez, threw him to the ground. But guess what? Cal Mossad didn't hit Douglas Sharp. Neither did this defendant hit Douglas Sharp. Even though at one time he was kind of in the vicinity, but he was like this. So it gave an indication to this defendant that I'm not in this fight. And guess what? They weren't touched. He was not touched. Neither did Mr. Wimpey touch him, and neither did Douglas Sharp. The individuals that he felt was a threat, he defended himself. Now, you see from the onset of this, he was provoked over and over and over again. And you see at the times where it was kind of, you see his hands are like, what are you doing, man? What are you doing? Look at you. Like, look at you. He's trying to talk some sense into him. And even on closing, Brother Khan said, Arthur Richter started the fight. We strongly believe Arthur Richter started the fight. It wasn't just words, by the way. It was the actions, the fuming in his eyes, the jumping around, the going to grab a weapon and coming at this individual and violating his space. It was not just words, ladies and gentlemen of the jury. This is not just the words. And then at one time you see the chest bump. That's when he took action. He felt he was threatened at that particular moment to the T where he had to take action and subdue this threat. The last time when he threw, and you know what's funny about this case, ladies and gentlemen, jury, the prosecution could tell you what he should have done. You know what's funny about this case is we actually have evidence of exactly what they want you to think as to what he should have done, and look what happened when he did do it. So he should have walked away, left. Guess what? He tried to leave. Even though he wasn't driving, they tried to leave. Try to get back, and they're done with this. They tried to leave. And guess what? Exactly as he perceived that threat, he was absolutely correct. He did not stop, which I call a chihuahua. He did not stop. He kept coming at him. Even to the extent when they got in the vehicle, they're gone, they left the premises, he throws 2 bottles at them. Both him and Ms. Warford basically said, I was afraid he may bust the window and come into and hurt me. That's bodily harm, a threat of bodily harm. And then guess what? He tried to leave again. Again, he came out again. And this time, they kept watching him. They moved out so they can keep watching him and eyeing him so they don't get assaulted again by this individual. Now, the prosecutor said, well, he could have just left when he left the last time and went back. Well, you see him when he came the last time back almost into the bar, he stopped. You see his friend walk in, so now his ride, his friend, who he thought was possibly in danger, he had to go back in. And that's at the time that the deceased, Mr. Vasquez, throws a punch. It's in the video. He throws a punch. And again, Mr. Wimpey, to back up the threat, punches him with the left jab. That's where he got knocked out. So, ladies and gentlemen of the jury, first, you're not going to find that this individual caused serious physical harm because he wasn't using, in our mindset, any sort of weapon, any kind of thing that he knowingly had caused, in our mindset, that he actually knowingly caused serious physical harm. Second, that's not murder. Second, voluntary manslaughter, there was provocation. Of course there was provocation, but I tell you again, he didn't knowingly cause serious harm to this individual. Because again, he did not intend, neither neither was there the clear element of causation in this particular case from our testimony and our witnesses. And lastly, ladies and gentlemen of the jury, even if you find murder, even if you find complicity of murder, even if you find voluntary manslaughter or complicity of voluntary manslaughter, he still has self-defense. No one can look at that video and say this person did not have any threat in his mindset. That's a defense. And the law is very clear as to the issue of self-defense. If there was not deadly force used, he does not have to retreat. If there's deadly force used, he does have to retreat. He wasn't using deadly force. He doesn't have nothing in his hands. And at the end, they did leave. He was simply just defending himself. He didn't want Mr. Vasquez to die. He didn't want anyone to die. When he left that bar, Mr. Vasquez was reading. He was on the floor. He didn't even know. They didn't even back up. They just left. He didn't know. It was 4 days later. 4 days later, he turned himself in, gave a statement voluntarily to the police. So this is what happened. He didn't mean for this to happen. He didn't have any weapon. He didn't have any occasion to sit there and really do some serious damage to this individual. He doesn't know this individual. He doesn't know Arthur Richter. He doesn't know Mr. Sharp. He doesn't know anyone in there. He just got put at the wrong place at the wrong time. And we can all sit there and second judge at what we should have done, could have done, would have done. You know, hindsight is 20/20. We don't really know what an individual do unless you're in those circumstances. But I know one thing. That was a very dangerous man, Mr. Richter. You could just look at him and see how dangerous. You could see by his actions, just kind of nothing was going to disengage. And you hear the testimony. I'll end you with this. You heard the testimony of Mr. Wimpey say, if he was that emboldened, coming at me, a guy twice his size, even though his arms are, what's he hiding? What is it that he's coming at me with? What's emboldening him so much? What's giving him the confidence? So ladies and gentlemen of the jury, I ask you, and by the way, this is the last time I'll get to speak to you. So whatever the prosecution, he gets the last word, that's their case, I don't get that opportunity. But I can tell you that whatever he basically says will be able to counter, we feel strongly. And at the end of the day, the burden in this particular case, they have to establish their case beyond a reasonable doubt on each and every element of the crime. Beyond a reasonable doubt. And ladies and gentlemen, as I said in my opening statement, beyond a reasonable doubt is not, oh, I think Mr. Wimpey did it. Ladies and gentlemen, that's not enough. I think he did it, but I'm not sure. That's not enough. He more likely than not did it. That's not enough. That's not enough. You have to be absolutely certain, beyond a reasonable doubt, that he did each and every element of the crime, that he knowing they caused it, everything else. And lastly, even if you agree with all that the prosecution proved each and every element of their crime, he still has the defense of self-defense. Yeah, he might have did it, he might have did this, he might have did that, but he'd done it in the mindset of self-defense. Ladies and gentlemen of the jury, thank you so much for participating. God bless you, and we ask that you bring back a verdict of not guilty as to all counts. Thank you.
Thank you.